Hi, folks. I'm Denise Howell. And next up on This Week in Law, we've got UCI's Jack Lerner, lawyer Adam Sanderson, Franklin Graves, and me. We're going to talk about video games and piracy, the status of the Happy Birthday lawsuit, the status of the Alice case and how it's impacting current patent cases, podcast patents on the run, and lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, episode 269, recorded August 1st, 2014. Blame it on Rio. Help support Twit with your Amazon purchases. Visit twit.tv/Amazon. Click on the Amazon banner and shop as usual. That's twit.tv/Amazon. And we thank you for your support. Hi, folks. Denise Howell here. Thank you so much for joining us for This Week in Law. I am super excited about this week's show. We have our old friend and former intern, Franklin Graves, joining us. Hello, Franklin.
Hey, Denise. How's it going?
It's going great. I'm sure it's going great in your neck of the woods now that you are 2 days off of taking the bar exam.
So happy. I feel like a huge weight's lifted off my shoulder, at least until October when results come back.
Yes. Well, you've got a few months to kill until then, and we definitely want to hear about the bar and some interesting technological snafus that took place this year. But before we get to that, we have two other great guests joining us this week. New to the show is Adam Sanderson from the Reese Gordon. What is the final name in your firm?
It's
title?
Reese Gordon. It's Reese Gordon Mercados.
Reese Gordon
Mercados.
Marcados firm in Dallas, Texas. Sorry, I flubbed that, but I'm not going to flub welcoming you to the show. We're very excited to have you join us today. Adam does a lot of patent law, and obviously there's been quite a bit going on in that arena lately, so we're looking forward to getting your take and insights on things, Adam. And also joining us to return to the show is Jack Lerner. Hello, Jack.
Hi, nice to see you.
Nice to see you again, too. The last time Jack joined us, Jack, you were at USC, and you're going to be coming down the 405 or the 55, however you're going to get down here, to UCI very soon.
Among about 5 other freeways, yeah. I've just joined. Exactly. That's right. I've just joined UC Irvine School of Law, and I'm very excited about it. Just started over the summer. And it's really exciting because it's a new law school, and so the faculty have really had a chance to sort of think and get on the same page about what the law school is about, and it's really a vibrant place, and they're doing a lot of really interesting things there. Or I should say, we're doing a lot of really interesting things there.
Yeah, you are. The UCI Law School is what, maybe, is it quite a decade old at this point? 6 or 7 years old?
It was started in the first class joined in, I believe, fall of 2009, and then the first graduating class then was in 2012, and so they've now just had their third graduating class. We just got accredited by the ABA, which was a very kind of a slam dunk thing, which is great, and it's really exciting. We're still hiring quite a bit, and I was brought in to start a law clinic similar to the one I had been directing at USC. And so this fall we'll be starting the UCI Intellectual Property Arts and Technology Law Clinic. And every school has law clinics where students practice law under faculty supervision. It can be anything from landlord-tenant to criminal justice focused clinics, immigration clinics. And there are a few tech-oriented law clinics around the country. There's probably about a dozen or maybe 15, and about half of those do tech policy and do wider issues around technology, and the others are more just straight up transactional and do things like patent prosecution or just licensing exclusively or something like that. So this clinic is going to do a wide variety of stuff, everything from amicus briefs to regulatory comments, but we also will be counseling and advising a really wide range of folks, from local entrepreneurs, particularly in Orange County, to local filmmakers and artists and people in the arts community throughout Southern California. And we'll also be working with people in the developing world, government agencies or nonprofits that are struggling with IP issues around the international IP system. And there's a lot of a need for technical assistance and expertise in the developing world. So I'm really excited to bring that to UCI.
It's really wonderful that the law school, is this young and still paying such close attention to the important issues that you've been dealing with at SC and now are going to broach in your clinic at UCI. It's very neat, and we're excited for you and for all the students that get to participate in your classes and your clinic.
We're going to have fun.
Go ahead.
Oh, no, I was just going to say we're going to have a lot of fun.
Yeah, you sure are. It's got to be more fun than Franklin's been having, because Franklin just took the bar exam. And it's sort of a sad truth that you can have a good deal of intellectual fun in law school and participate in great clinics if you're fortunate enough to have Jack Lerner at your law school, heading one up in an area that you're interested in. I'm sure Franklin would have loved to participate in that had he had the chance. But you do all that, and then you have to take this arduous 2 to 3 day, in California it's a 3-day exam that we were talking before the show. I really think that if you wanted to test for ability to practice law, there's got to be a better way to figure out how to do that than the way the rigors that we put people through. You may as well just pull people, get the roster of people who's successfully summited Everest, because it's a terrible endurance test the way the bar exam is set up now. And this year even more so. Franklin, what happened?
Yeah, so I guess kind of taking a step back is you have two options with the bar exam. Every state has a board of law examiners, and they give you the option to either handwrite the exam or you can use a computer. And kind of the way that if you think about it logically, there's no reason to not do it on your computer, because most people, I would assume, can type faster than you can handwrite, and it's so much easier to edit and you can cut and paste on the computer. I mean, you can't do that with paper, but so the Board of Law Examiners in some states give students the option to use software, and you install it on your computer about a month or two before the exam, and it basically shuts down your entire computer except for that one program, and it keeps a log of everything that happens on the computer, so they can see if you access something else, or they basically can watch whatever happens on the computer during that time. And there are two companies, and one is Extegrity, which does Exam 4, and that's what I was more familiar with through actual practice in law school, because they have a software called Exam 4, and Exam 4 is the exact same thing as ExamSoft, which is the second company, and they both offer this program that you install on your computer. But with Tennessee, we took it using ExamSoft. And ExamSoft, you open it up. The first day of our exam is the essays. So you start out with your laptop, you're typing it all out, and it saves a local copy of your essays to the computer itself that you're working on. And then at the end of it, you upload it to ExamSoft servers. And from there, it gets graded by whoever. So essentially what was going on was, after the first day of our exams, the instruction sheet that they had in front of us said to either go back home or to your hotel or to your apartment and upload it later, rather than bog down the conference center's Wi-Fi that we were in. But they were very helpful. They had ExamSoft reps on the site at the location that we were testing in, and so they would walk around during the exam. Obviously, there are issues with computers, and so a couple people I actually saw during the exam had to switch over to using paper, either because their computer froze or something like that happened. And so at the end of it, you can upload it there. And I connected to the Wi-Fi, thankfully, and uploaded it before I left the conference center. So I did not encounter any of the issues. But I get on Facebook around 6 o'clock that night, and most jurisdictions said you have to upload it that same day by 9 p.m. or midnight. In Tennessee, it was 9 p.m. And so I was on Facebook around 6 o'clock trying to get my mind off the next day's testing. And I start seeing all these updates from other students that are talking about how they can't upload their files. And part of the rules were if you don't upload it by 9 p.m., they won't be graded at all. So all of this breaks out. There's obviously an issue with uploading the exams. And from there, it caught the attention of Above the Law and a bunch of other news media sites because Twitter was blowing up because the company ExamSoft has a Twitter feed, and people were complaining to them. And then it just became this whole kind of effect where everybody started complaining online if they weren't uploading. And obviously it's a stressful time for students and examiners and trying to upload and it's not uploading and you have this deadline you're trying to meet. So ExamSoft, I don't know if it was them or other like state board law examiners decided to extend the deadline to the next day. But that still did not help some students because it was not uploading even the next day. So it's all of this culmination of stress that's going on during the exam plus technical issues created this whole online issue of people complaining openly to the public at this Florida-based company. And it was just a disaster overall for their public image, at least.
There are a couple of hysterical hashtags that people can look up if you want to see the poor struggling law students and how they were moaning and complaining about all this in real time. There's Barmageddon, which I thought was quite clever, Barghazi, and Barfail 2014 on Twitter. All of those should get you some funny tweets, such as one that Above the Law highlighted. Somebody said this ExamSoft thing will fuel the number 2 pencil industry for years. And, you know, that's how I took the bar exam, was with a pencil and blue books. And it used to be that you had to get special dispensation to be able to use a computer. Now, as Franklin was saying, I'm sure that for most people, it's done in a typing format rather than the other way around. But of course, just like with our healthcare services, you need to have the infrastructure in place before you start having thousands of people trying to hammer that infrastructure at the same time. Jack, as a professor, are you feeling sympathetic about any of this?
Oh, absolutely. You know, you get to know your students so well, and what, you know, and you're kind of, you're not obviously with them taking it, but, you know, I'm always thinking about my students, and I know which ones are taking it, which ones are going to take it next year. And, you know, this actually catastrophic. There's a Barmageddon every 3rd year or so. You know, in the Massachusetts bar, about 8 or 9 years ago, there was some kind of construction going on next door. There was climate control issues. It was extremely loud. There was like water coming into the room, and a bunch of people. What they ended up doing, I think, was they took out one test score, like the lowest score for a bunch of people, and of course that was very controversial, something like that. And you know, it's a problem. It's an infrastructure problem. The way I see it is, if you're going to have a really difficult test that takes 6 weeks to study for and 2 or 3 days to actually take, that's a huge barrier to entry, right? And why are you doing that as a bar association? Well, the noble reason is because you want to make sure people are prepared to practice law. The less noble reason is because you want to maintain a high demand and a lower supply, you know, therefore try to get a higher demand. Then, you know, you really ought to be able to make sure that everybody's taken care of and that you have the infrastructure in place. And if you can't find the right contractor to do it, then, you know, rent a room big enough for people to come and take it there. I mean, maybe that's not a good solution because that's a lot harder for people. You know, when you and I took it, Denise, I don't know about you, I rented a room in the hotel where it was being given, which was the Oakland Marriott. And, you know, that costed several $100s for 3 nights or 2 nights or whatever it was.
Yeah, I also took it in Oakland. I was staying close by. I was living in San Francisco at the time. And, you know, you're so paranoid about the test that I did go over to the other side of the bay and stay close by, but not right in the hotel. And, you know, there are stories that go around. I remember when I was taking the test, I don't know if this is urban legend or not, but that someone somewhere taking the bar exam had collapsed in the middle of the exam, and that other students had tried to help that person, but that the helpful Good Samaritan students were thereafter penalized because they had taken time out from their actual testing to ensure that the person had proper medical care, and that, you know, there was no relief from that. So again, I have no idea of the validity of that story, but that's the kind of thing that's flying around in the ether while, you know, you're taking the test. And to have a company telling you your upload will not succeed right now, please try again later, has got to be just terribly nerve-wracking for a test that not only is difficult to take, but so difficult to take that people like former Stanford Law School Dean Kathleen Sullivan have taken it and failed. So, you know, there's just a lot of emotion going on. And clearly, if you're going to let down a bunch of people with your technology, you don't want to pick a bunch of newly minted lawyers to do that too. Adam, any thoughts on this before we move on?
You know, I think that's right. The last constituency that you want to offend is probably some brand new lawyers. And if it's not the brand new lawyers, it might be the law firms that are trying to hire the brand new lawyers so that they can give them a job and bring them in. So I think if I were a technology company, I wouldn't want to upset law firms hiring lawyers, right?
Yeah, no, you wouldn't want to. And
Denise,
certainly, yeah.
Sorry, if I might add, I think part of the reason everybody's so upset is that we paid 100. Well, in my jurisdiction, it was 100, but through social media, I found out that other jurisdictions, it was 150. So I don't know why it was the same software, but there's a price difference. So I think people wouldn't be as upset if we hadn't have had to pay an extra $100 or $150 on top of the bar examination fee and all the other fees that are associated with it. So I think that added to the frustration that we're paying this company just to have on the one day that they're supposed to perform, to not have them live up to what they promised would happen. So,
right. Maybe it'll be a lesson for the various bar examiner boards out there that they need to have some competition in their test taking software and give people some choice, and, you know, have a number of accepted companies you can go to.
We're getting some pretty funny comments on the IRC. It's pretty funny. One person says, our predatory supply-demand model is getting long in the tooth, and I think that's true. There's a lot of movement toward bringing in people with different kinds of qualification, you know, somewhere between a paralegal and a lawyer, right? And then there's another comment I thought was interesting. It's like 0.1% problems, you know, and on the one hand, that's true, and on the other hand, people take the bar exam all over the world, and they have infrastructure problems with those too. The only difference here is that we're taking them electronically, but this happens. It happens with professional exams. You know, people, you know, snafus occur, right? But the question is, how does the organization deal with it, right? And do you make it right, or do you end up making people take it over, or what is it going to be? You know, the bars where this happened need to step up.
They do indeed. And I did not mean to spend quite so much time on this particular topic, but since here in California, we just wrapped up the bar exam yesterday, I'm sure it's fresh and raw in many people's minds, to the extent they are awake after having gone out and recovered last night after the test. Let's talk about some copyright things. And it's so fun to have our little transitional bumpers there play on this particular show because Franklin made them. Yay. Thank you, Franklin, for our bumpers. You know, I'm not sure why exactly all of a sudden last weekend, the happy birthday lawsuit story against Warner Chappell that was filed about a year ago. It's about the birthday of the happy birthday lawsuit. Maybe that's why it's being talked about again. It is still wending its way through the courts. Not much has happened there, but people were sharing the link to the original filing of the suit as though it had just been filed. That's not the case. It's about a year old at this point. But it's a very fascinating case, and it deserves looking at afresh a year down the road. What is happening here is that Warner Chappell, who claims to have the exclusive copyright to the song Happy Birthday to You, is being sued on a number of theories, most of which revolve around the fact that Warner Chappell never had the copyright to the song to begin with, that it was in the public domain from way, way back. So this suit is still pending. And not much is going on with it right now. It's still in the discovery phase. It is now on its 4th amended complaint, which has been answered. And the most interesting thing that is set to happen in the suit is in November, the parties have their deadline filing motions for summary judgment. So we should see some substantive arguments there and see the parties put their cards on the table and see, be able to make some armchair quarterback predictions perhaps about where the case will go. So Jack, have you been paying attention to this? And do you think it's as interesting as I do?
I think it's fascinating. There's so many different things you can think about when it comes to the policy of copyright policy, and also when it comes to this particular case and questions like this, right? So we just had a case, I think it was decided early this year or late last year. It was decided one of those about Sherlock Holmes. And the Sherlock Holmes estate had been asserting copyright over really more than it owned, because a lot of the key early Sherlock Holmes material is already in the public domain. And because he did a lot of stuff before 1923, and then he did some stuff after 1923. And for public domain, that's a key date. And the Sherlock Holmes estate was not going to roll over and say, okay, well, we'll just give back we'll just let people use it now, or we'll just give back all these royalties or whatever. They fought tooth and nail, and in the trial court they lost, and they're going to lose up above, because I think it's a pretty clear-cut case. I think it's also pretty clear-cut. I think it's clear-cut, and I think the prediction's easy to make that Warner Chappell's ultimately going to lose for a couple of different reasons. The first reason is because there are some really good arguments about how the copyright was originally obtained and maintained over the 75 plus years, or 100 years almost, whatever it is, over the decades between now and when the song was originally allegedly put together in the teens. We went through many different changes to the copyright law, including in 1976, a huge, massive change, but many little changes throughout there in different periods where we had to re-register and stuff like that. And you can get into the nitty-gritty on, I think, one of the links that you posted, Denise. So I think that's one of those is probably going to win. But I think there's a bigger reason why, which is that a lot of litigation, and copyright litigation is no different, fair use litigation is particularly like this, but a lot of litigation is really about the story you tell. And it's about what's going on in society, or what's going on in a case, or whatever it may be. And I think that's what there's so much outrage and discomfort with the length of copyright terms. And in this case, this is also something that has become part of our culture that we all feel ownership over. Happy Birthday, it's almost like the Star Spangled Banner, which of course is in the public domain for a long time. But there are many songs like that. But when you talk about sampling, when you talk about referencing, look at Reddit, and look at all the ways that people use memes, and they use Spider-Man, or they use the guy with the Louis Vuitton hat, what's it, Bad Guy Steve, or whatever he's called. They use these pictures as words, as pieces of language, as tropes. And Happy Birthday is a part of basically every American's life since they were a tiny child all the way up until now. So the idea that would still be under copyright doesn't sit right with people, both because it's part of our culture, but also because it's just so old, right? And so I think that that seeps into litigation. That seeps into the ether of the case, if you will. And I think that's one of the reasons that it's not that hard to predict that ultimately Warner Chappell will lose. That might be 10 years from now, by the time it's completely finished, or 5, because I guarantee you they will fight this tooth and nail, particularly because it's not just saying going forward we want a declaratory judgment. In this case, they're saying this is a class action and we want you to compensate everyone since 2009 who has licensed this from you, right? And so not only would they have to pay out, but they would lose out other. Not only would they lose out on future revenues, but they would have to pay out. So I predict they'll fight it. I don't think they're going to settle. They would also be very embarrassing and would call questions into Warner Chappell's other behavior. Well, what else are they asserting copyright over that they might actually own, and so on. So I think it doesn't look good for Warner Chappell, but it's going to be quite a while before people that want to put Happy Birthday into a fictional film, a narrative film, are going to be able to do that without getting a letter from Warner Chappell.
Right. Virgil in IRC is suggesting people use the Beatles' birthday song, but then you've got the whole raft of copyright issues and licensing issues around that. So not so much a good alternative. Franklin, you have any thoughts or suggestions?
Yeah, I would agree. I thought Jack brought up a great point that this is a great way to get people to talk about the current length of copyright. I mean, what a better example than Happy Birthday for people to get upset about the current length and term of copyright, especially when there possibly might be reform going on or efforts to reform the current Copyright Act as it is. And so I think it's a great starting point to get people to discuss issues that are in copyright. But I think Jack just did a great job explaining the whole court case and the outcomes that are potentially available. So I think it's going to be interesting to see. And I also agree with the fact that Warner Chappell can't necessarily go back and just say, oops, we made a mistake, we don't have the copyright in this, because I understand why they're still fighting it, because they have a company image they have to protect, and they who else is going to call into question any other rights they might have underneath their record label or the group of record labels they have.
So a scholarly article that really unpacks all of the copyright ramifications here is highlighted. There's a great blog post done at Many Fighting Faiths, which appears to be by a law student who had the professor who's being cited so repeatedly in the lawsuit. I'm going to butcher his name. It's Robert Bronies, maybe, if I'm getting that right. But I've gone ahead and put it with the rest of our discussion points at This Week in Law, delicious.com/thisweekinlaw/269 if you want to look at that in depth. It is available on the web and for your perusal. Using that as our segue, putting things on the web that are research and educational oriented, thought I'd just mention that there is a Shades of Aaron Swartz story going on in Colombia, where a student is being criminally prosecuted and faces up to 4 years in prison for uploading an academic article to Scribd. I read about this a few weeks ago, and we haven't mentioned it on the show yet. I believe he was an oceanography, marine biology student, and there's some good discussion. I think the EFF wrote this up, as well as over at TechDirt, about the difficulty in accessing the academic materials in this particular student's field. Yes, the EFF did write it up as well. So the upshot here is there are some good arguments to be made in his defense under Colombian law, and he is fighting this battle now. So it's something to pay attention to, and an ongoing issue of access to academic materials online in a way that doesn't involve a restrictive paywall. Jack, do you have any thoughts on this?
Well, I mean, it seems excessive, just as as the Aaron Swartz prosecution seemed excessive. He's being threatened with 4 years for 1 or 2 articles. Am I correct?
Yeah.
As opposed to 30 years for thousands upon thousands of articles. But
right.
I mean, these were public domain articles in the case of Aaron Swartz, and JSTOR had already said we have no interest in pressing charges. I mean, it's hard to say what's going on in the Colombian legal system and who's behind this and so on. I mean, I think that I think the bigger question is, how does this relate to U.S. IP policy internationally? Mm-hmm. And I think really this calls into question, to what extent Colombia is as a government has been much more pro IP rights than a lot of the developing world. Much more. They're one of the most aggressive in terms of their laws and in terms of their stance. And I guess I don't really know this to be the fact, so I'm surmising a little bit. But I think part of the reason for that is because we have cooperated so closely with them on anti-drug enforcement type activities for many years. We give them a lot of aid, and so the American influence over IP policy has been stronger than in other countries like Ecuador, for example, or something like that. So, I think that maybe this has to do with that. Maybe this was influenced by that relationship. I have absolutely no reason to believe or evidence or anything like that the U.S. has anything to do or even cares about this particular case. But when you think about the overall policies, the U.S. PTO and the U.S. Trade Representative really have pushed, with some exceptions, but they've pushed very aggressive IP policies, and some that would actually make it difficult to reform U.S. copyright, and some that arguably even run counter to U.S. copyright law as it currently exists. For example, would it make fair use harder for us? Orphan works reform might be problematic. And so, we've pushed a very aggressive IP policy around the world. We've asked our trading partners like Colombia and others to adopt policies that might be more aggressive than what they would have wanted to do on their own. Lo and behold, a student is being prosecuted in one of those countries that has acquiesced to the kinds of things that we've asked for more than most other developing countries. Lo and behold, in one of those countries, somebody is being prosecuted for downloading an article, right? And when you think about how things work in the developing world, access to educational materials is extremely difficult there. Piracy is the default of educational materials. I wouldn't call it piracy necessarily, because if there's no market for those, if a textbook is not being marketed and everyone makes photocopies and there's no license structure in place, to what extent is that taking care of what's considered a fundamental civil right, which is the right to education, or is that being considered piracy? Beauty is in the eye of the beholder. But the point is, all over the world, and you can see this in the report that Joe Caraganis and and others put together, and I can post a link here in IRC, but it defaults around the world. Universities around the world, all through the developing world, photocopy the educational materials, and most of that is not licensed, right? So for this person to be going to jail for downloading one article is particularly outrageous given that international context, that global context for access to educational materials. And even this access to research materials, obviously it seems excessive, but I think it's more excessive there where there is no market often for legitimate materials. I mean, you can't even buy stuff online sometimes because you need an American credit card.
Right. The student's name is Diego Gomez, and we'll continue to watch this and to pay attention to the impact of U.S. IP policy getting exported to our trade partners. Adam, did you want to weigh in here?
I would just point out that, of course, it is excessive what's happening to Mr. Gomez in Colombia. But another thing to keep in mind is that, for all of those businesses and individuals that run an internet website or conduct electronic commerce, if you're doing business across borders and you're doing business with other countries, you really have to make the effort to educate yourself on how those other countries treat intellectual property, because intellectual property is always a trade-off. Governments grant certain exclusive rights to authors and inventors, and in exchange, at some point, the material and the inventions or the artist's creative work becomes part of the public domain. But what you have to know is that every country treats it very differently. So here in the United States, we know that there's copyright laws, but there's also exceptions that protect researchers and protect teaching and the fair use doctrine. Colombia doesn't have an equivalent of the fair use doctrine. So those exceptions that are common in the United States and they're common in a lot of countries around the world, they don't exist in Colombia. So what is happening to Mr. Gomez is tragic and excessive and inexcusable. But I think it does make us reflect and remember that if you're in the United States and you're trying to do business with countries and across borders, you've got to be very cognizant that the laws are very different. We're not talking sometimes subtleties. We're talking, night and day difference. So I think that's one thing to keep in mind.
I don't disagree with anything that Adam said there. I think that all makes a lot of sense. The only thing I would add is that not only do you need to understand the environment in terms of infringement, in terms of intellectual property laws of these other countries, you have to think about, are you making your product available at an affordable price that is gonna be accessible to people, right? And so, when DVDs are sold for the equivalent of $200 in a place like Brazil, where if it's being sold for the equivalent of 3 days worth of wages or a week's worth of wages, no one's going to buy it, right? Or maybe it's not being marketed at all, which is the case for a lot of educational materials. And so I would say I think there's a real need for access across borders for some of these products that hasn't been met yet.
Right, and just to pick up on a couple of threads you both raised, I visited Colombia a few years ago just on a purely leisurely recreational tourism kind of trip. And anecdotally, my thought about the place was that it was really determined to be business friendly, that it really wants to be the place where, if you're not able to do business because of heavy regulation, et cetera, in other countries, you can come to Colombia and do business there, which, will have its own raft of repercussions for the country as it goes forward. But having such a strong IP rights holder stance in copyright law, I think kind of goes hand in hand with that. And again, it's something that people should be aware of if they do sort of take the country's economic invitation and decide that Colombia is a good place to do business or headquarter or trade with. Let's move on to something equally interesting, a little bit closer to home. And that is the automakers that are getting sued here in the U.S. for their CD players in their cars. Ford and GM are both being sued for technology that enabled drivers to have a library of music in their car that had been ripped from CDs. Of course, that's not the only thing that the audio system in their car did, but it was one of the features. And they're getting sued by the Alliance of Artists and Recording Companies, AARC, a nonprofit group representing more than 300,000 artists, for $2,500 per unit of these particular audio systems, which number is supposed to be tied to the lost licensing and royalties that AARC claims it would have been due had this music not been taken straight off a CD. The claim here, the legal claim, is that there's a violation of the Audio Home Recording Act of 1992. So if you remember the Kaleidoscape case, this at first blush sounds a little bit similar to the company that got sued because they allowed you to create these enormous DVD jukeboxes in your home. The difference there is that DVDs have copy protection and most CDs do not. So AARC here had to find a different theory, and their theory has to do with the fact that under the Audio Home Recording Act, if you're distributing a digital audio recording device with the primary purpose that device will rip copyrighted material, that's prohibited under the law. So interesting case here. Jack, what's your take?
Well, on the one hand, again, this is something that the automakers are going to fight tooth and nail, because no matter how much you spend on lawyers, unless you're Google and Viacom, you're not going to get into the hundreds of millions of dollars range. So So I think this could go on for a while from a practical standpoint. It's possible that a settlement would happen, but we'll see. I mean, the Audio Home Recording Act has some exemptions. For example, and this is under the Audio Home Recording Act, which says that when you make CDs, you have to give royalties to the recording industry. And so I'm actually a little bit surprised that whoever they contracted with to put the CD players in there hadn't taken care of that. It seems like something of an oversight. But so that's one thing I'm a little bit surprised about. I think there might be problems with the class. The class seems to be, and Consumer has pointed this out, the class seems to be rather pretty diverse. And so it's, being a class action, that's always something to think about. But I also think, there's a lot to argue about here in terms of the facts and the law, because the Audio Home Recording Act contains some exemptions, like personal use exemptions, and it contains some exemptions around, it is exempt, for example, CD burners in computers and things like that. So I think there's going to be a lot to fight about here. I don't think it's a black and white issue. I don't see it as utterly insane, or completely completely bleep that out, please. Completely insane. People come up with creative lawsuits and they go after people with deep pockets all the time. I mean, I've seen many less plausible lawsuits out there, whether in copyright or in other areas. So we'll see what happens. I don't know. The Audio Home Recording Act is a bit of a weird animal, and so this one's a really wonky copyright nerd question.
Yeah, it's particularly wonky. People in IRC are pointing out that CDs in cars and having a big CD library in your car is probably, as current as listening to the Steve Miller Band. It's just not something that a lot of people are worried about for auto technology going forward. But that doesn't mean that there's not a big dollar lawsuit to be had here over the technology that was in place. Right. Adam, you were mentioning the fair use doctrine a minute ago. I remember, speaking of, things from decades past, I remember there was a big controversy and a lot of people paid attention. I think it was during the Napster litigation when one of the recording industry's lawyers in oral argument actually acknowledged to the court that ripping a music CD with no copy protection would be a fair use of that CD. Now, that's not, any sort of citable precedential law, but it's a telling admission. And I'm wondering what you think about the fair use doctrine's application in this case.
Well, I think the fair use doctrine is going to be a problem for the plaintiff for certain. But what jumps out at me first, as someone who has a background in software and as a litigator of software matters, is that the statute, like you said, Denise, this is the Audio Home Recording Act. That's not a statute that has seen a lot of litigation. It was passed in 1992. And, if you remember, and I think this gets to your point, if you remember, there was a case that had to do with the MP3 player, the Rio, back at the early 2000s. Mm-hmm. And that was a case kind of like this one, where the record studio and the industry and the artist brought a lawsuit claiming that the maker of the Rio MP3 player had violated the Audio Home Recording Act. And that went up to the Ninth Circuit, and the Ninth Circuit threw it out and essentially said, the only way you can violate the Audio Home Recording Act is if your device qualifies as a digital audio recorder. Now, most of us would think that an MP3 player, the Rio in particular, would qualify as a digital audio recorder, but the court said it didn't. And the court went on to say that that act is really not intended to affect individuals' private use of listening to music and copying digital music files. So the Ninth Circuit so gutted that statute that we really haven't heard anything from that statute. No plaintiffs have really brought cases under that statute, or at least not very often, certainly not to the same degree that happened then. So this this strikes me, as certainly a strategy by the plaintiffs to avoid the more common claims that you would ordinarily see, and ordinarily you would expect to see maybe a violation of the Digital Millennium Copyright Act or some other statute. But I think these plaintiffs chose not to bring the case under the DMCA for the reason that you're getting at, Denise, and that is they would have this fair use doctrine defense that they would have a hard time getting past. Because if you go back and you look at the Audio Home Recording Act, that was a compromise in the 90s. That was back when, we didn't have a way to make perfect copies of digital music files like we do now. So in 1992, you had consumer electronics companies that were poised to release these copying devices. Now, we see them all the time, but they were basically CD read-write capability devices. And the music industry didn't want those devices to be released because they feared that it would lead to widespread copyright infringement and lost sales. So this statute, the Audio Home Recording Act, was put in place as a compromise. The device makers could release their device, and the music industry would receive a royalty on every device sold. So that's kind of, this lawsuit against Ford and GM is kind of like a time machine, the Wayback Machine, going back to 1992 and trying to recover these royalties that they bargained for 20 years ago, and seemingly found out 10 years ago, hey, that statute it's not as effective as you thought it was going to be, music industry. So this is an interesting choice by the plaintiffs to bring this case under that statute.
Yeah, and I think there's a couple of other pretty interesting points with respect to this particular case. One of them is that the AHRA actually isn't used very often, and very, very little royalties are actually distributed now. I don't think, they're asking for more royalties in this lawsuit than probably have ever been distributed in the history of the act since 1992. According to one site, in 2009, only like $16,000 or $17,000 was paid out to rights holders on behalf of from all of the royalties were collected under the AHRA. The other thing is, as Adam pointed out, I think this is important to point out, this is really more about machines that are used to make repeated copies, to make large numbers of copies, like CD burning machines where you have a lot more, you have a capacity to make a lot more copies. And so just the idea that you could use something to back things up isn't really what the act was intended for, and whether it actually meets the letter of the law remains to be seen. But I think if this is probably pretty likely to go the same way as the Diamond Rio case, which went for the manufacturers and not for the rights holders.
What do you think, Franklin? You paying attention to this at all because CDs aren't relevant to you anymore?
I think it's a very tough situation, but one of the distinctions I just thought of in my mind is that between the car ripping technology and an MP3 player like the Rio from a few years back, I think with an MP3 player, you don't have the ability to take any CD that's just around you and put it in the MP3 player. Obviously, that's not possible. You have to have some type of computer with a CD-ROM drive and a hard drive all attached and connected and ripping the CD that way. So that, in my mind, I can see as a logical exception to be able to back up for home use. Like, you have your CD, they get scratched easily, you can back it up to your computer so that then you can take it and transfer it to an MP3 player that you can carry around with you, etc. But I think with the car case, it seems like you have this device that will rip the CD connected within the vehicle to the storage device that will store it for who knows how long, like however long the hard drive is. And so I kind of can see how it's a little bit different than just a standalone MP3 player, whereas this, you can actually insert any CD. And I think it's kind of weird because who actually uses CDs anymore, I think, is the better question. But at the same time, I know they aren't arguing fair use under this act, this Home Recording Act, but I kind of shy away from the idea that just because somebody rips a CD or sells a device that's able to rip a CD, they should have to pay a royalty for selling that device that gets distributed randomly among artists. That just kind of, or record companies as well. And granted, I just need to go ahead and say I will be working for a record label here soon and starting next week. So I got to hold off and say I'm not speaking my own opinions, not anybody else's or anything like that. But in this instance, I think that it's pretty clear that you can go, it's fair use, and it's also incorporating the first sale doctrine. I can go to any record store here in Nashville. We have tons of used record stores and pick up a CD. And when I buy that, the artist does not see a penny of that money. And so I think that's a better argument to say, hey, somebody else is profiting off their music. And so the artist should directly get money for that sale. Obviously not underneath the first sale doctrine, but that kind of aligns to this where just because I put a CD in my car and rip it, why does that entitle somebody to make money off of that? Because it's still mine. I can understand if I sell the car a few years later and the hard drive is still in there and somebody else is then able to have access to all of my music that I paid for, that they're getting for free. Kind of like if you look on eBay, people that sell iPods full of music, or they used to when I was in high school, I used to look on eBay, people would sell iPods chock full of music already, illegally downloaded, and then you could just get all the music they had on there. So I think there's some distinctions between the MP3 player by itself and then also a car that has ripping capabilities attached with it. If that makes sense at all.
Yeah, it does. And your points make me think that, we're all, the undertone of our discussion here is that this is sort of an anachronistic lawsuit because so few people are using CDs and relying on CDs as their audio entertainment in their car going forward. But if that's the case, then the entertainment industry, I think, the music industry is in a better situation than it was when CDs were the default music delivery mechanism. Because as you point out, Franklin, you could buy a bunch of used CDs and not see a dime go to anyone on the rights holder side. But today, the reason that CDs are anachronistic is because more and more streaming is the way people go. And even though there's a lot of complaining about the royalties that are paid in that format, at least they are royalties. There is a payment being made there. So it just strikes me as technological progress and the law and the rights holders having somewhere to go as technology has evolved, and the piracy is less the go-to, and people are getting paid. There's still a lot of belly aching about how that's working, but at least we're seeing some progress there. And I think we're going to put our first MCLE passphrase in the show at this point, and it's going to be "Rip My Ride." So if you're listening to the show for continuing legal education credit in your jurisdiction or professional credit and you're not a lawyer, we put these phrases into the show so that your oversight board, whatever that may be, can see that you actually watched or listened to the show, which particularly today with Jack joining us is very academically and educationally worthwhile, I have to say. Let's move on to, we've already been talking about Hollywood and entertainment with music here. Let's do it officially with a bumper, shall we? Just a couple of quick things to hit on here. Note that as we're talking about piracy and the state of piracy, the Pirate Bay now has a mobile app that will help you find torrents on your mobile device and download them straight to that device. Again, I don't know, Jack, I'm starting to feel like even the Pirate Bay is anachronistic these days. What do you think?
Well, I don't know why. I think it's not anachronistic, particularly because I think it still gets a lot of traffic, and it's still where a lot of people find their torrents. People find them in a lot of different spots. It's not hard to find them. A lot more stuff is moving towards mobile. I mean, I think this has interesting net neutrality ramifications because if the mobile makers are now going to say we don't want all and rights holders and say we don't want all this torrenting going on of, predominantly or the vast majority of it being pirated material. And so we need to put sniffers on the mobile networks, and Sprint needs to put, and AT&T and all the other companies need to put other kinds of devices there. Or this is an excuse to throttle. This is an excuse why mobile doesn't, needs to. If you go back to 2010, the FCC said we're not going to have a no blocking rule on mobile devices because it's still a developing market and there's more competition and some other reasons. And so this might be an argument why to preserve that exception or that difference between mobile and landline, despite the fact that more and more people are depending on mobile. So I think that whether that should happen, I think we should have full net neutrality for mobile and landline. I think that's really important, fundamentally important. But other people might disagree. So. I don't think that this is an argument for having an exception to net neutrality on mobile. I think that it's an argument maybe for other solutions like RightsCore or other solutions like streaming. If it's the harder it is to get your stuff via legitimate means, the more piracy is going to happen. And so it's hard to compete with free, but it can be done. And you now have a lot of people paying into Rdio or Spotify. You have a huge number of people paying into Netflix. And if we see more of that, and it becomes a thing where, I like to think about cable. I don't want to go off on too much of a tangent, but if you look around, I mean, I spend more on cable than I spend on probably buying new movies or buying new music or paying for an audio subscription stream. I pay for Rdio. Combined, right? And routinely people pay $50, $100, $150 a month for cable. So people will pay for their content.
They will. And I guess, the cable companies have struggled with offering people the flexibility to watch what they want, where they want it. Just over the weekend, we had some guests here who were Comcast customers, and they were actually able to watch. I'm not sure what technology Comcast is using for this, but they're able to watch as though they were on their home system on a mobile device, which I remember a couple of years ago when Time Warner rolled that out. You could watch on your iPad. You had to be actually on your same Wi-Fi network that Time Warner was providing to your home. I'm not sure if that has changed either, but my point with this is just that, you're paying all that money, and I think the choice that people make is either to stop paying all that money to the cable company and go to the Netflixes and Amazons and HBO Go's of the world, although HBO Go has its own, tie to the cable company, so that's not a good example. Or you feel like you're getting value out of that you can actually use your content where you might happen to be at that time. So yeah, I guess there are people out there who still, if they're not going the way of paying through the nose to all the various different services, that torrenting on your phone would be a big deal. And I agree that the net neutrality piece of that is very interesting. What do you think, Franklin?
Well, when I saw this, I was like, this isn't anything new. Last year, I remember I was at Blue Coast Burrito, and I had a guy, one of my friends, he had his jailbroken iPhone, and he showed me there are torrent apps available all over the place on jailbroken iPhones. So, it's not necessarily a new thing to be able to do BitTorrent on your phone. Obviously, if Pirate Bay does something along those lines, it's going to garner more attention. But I think that it's, number one, from my opinion, I wouldn't want, if I'm torrenting a movie, there are many other uses for BitTorrent besides just entertainment purposes. But the vast majority of it that most people talk about and get wrapped up in are the entertainment aspects of it and profit losses, all of that. But in my mind, if it's for a phone, I'm not going to want to watch a movie that way. I don't have kids yet, and I know it's completely different when you have kids. So maybe there is a use for it. But in my mind, I don't see a use.
I think Franklin froze up there on us. I'm not sure if we lost him or not, but we will soldier on and try and get him back. Adam, mobile BitTorrent, big deal or no?
It strikes me as the latest in this arms race of where, on the one hand, the providers of free, copyrighted but infringing content are trying to make it easier so that you can download and infringe copyrighted material and watch it. And then meanwhile, like you said, all these services that provide it to you legally, frankly, they're inconvenient and they can be a real hassle. And no, you don't want to watch a movie on your phone, but you certainly will watch a movie on your tablet, especially if you're in an airplane. And just recently I was on a business trip and trying to download a movie from Amazon and then watch it offline on my iPad turned into a big headache and a big inconvenience, because although it's possible to do it, but to do it you have to jump through several steps. Torrent in that case would have been very easy for me to do. So I think what the content providers need to do, instead of making it more inconvenient, is continue to practice making it convenient to follow the law and watch content. Because as long as it is so inconvenient to use Netflix or Amazon or some of these other legal sites, there's going to be a demand for torrent. And so the fact that Pirates Bay is moving to the phone, that's not a big deal. That's just a natural evolution.
Franklin, now that you're back, you made me think that the mobile BitTorrent, the unintended consequence of mobile Pirate Bay, will be a huge surge in the illegal torrenting of things like SpongeBob, right? Because as you hit on, people will put that on their phone and then occupy their child for a long time in a store or a restaurant, for example. All right. Mobile Pirate Bay may be one of the first sites to get this new kind of treatment from the London police, who are going to begin the City of London Police in London, UK, are going to start. Now, this is a clever little tactic they're using. They're for sites that they believe are offering unauthorized, infringing materials. And it would be interesting to get into how they're making that determination and what sort of evidence is being submitted here, because this strikes me as something, very sort of prohibitory step that's being taken without an actual trial. So the due process questions arise. But in any event, what they're going to do is replace the ads that would ordinarily, the banner ads that would ordinarily appear on the allegedly infringing site, with a warning from the London police letting people know that this site is under criminal investigation for copyright infringement related activities. This is from an article at ZDNet by Joe Best. So it's an interesting, it raises a bunch of issues, an interesting tactic, a novel approach, certainly, toward letting people know that they might be putting themselves at jeopardy for copyright infringement if they continue to use the site. Jack, what do you think of this tactic?
Well, this is similar to a lot of tactics that you see when you're talking about enforcement and you're trying to do it in a nimble way or in a creative way. The question comes up, well, how do you account for due process here? I mean, what does it mean you're under criminal investigation? On the one hand, that's pretty heavy-handed. On the other hand, that's a lot better than saying, we don't know you, we don't know who you are, we don't even know if it's you, but we think it's you because of an IP address that was used, so we're going to give you one strike. So in a way, this is heavier because it's the government and not the ISP. And in a way, it's actually a lighter touch than if the ISP actually says, well, now you have one strike, and if you get up to 3 or 6, depending on where you are, you're going to be in trouble, But it's just it's a thorny. I mean, I sympathize with rights holders to a degree to say, we want to stop piracy, but at the same time, I have to say, people have due process rights in the UK. They may not be equivalent to ours, but they do have due process rights, and this seems pretty heavy-handed. So, it's a tough call. I'd like to see how this plays out. Before I come down and say it's absolutely unacceptable. But honestly, I mean, it at a minimum, it's very heavy-handed. What are they doing? How are they figuring this out? I would like to see to say, this is why we think this is the case. Here's a number you can call if you disagree. Here's a hotline you can call. You can talk to us. I mean, have some procedures there so that it's not just this single communication that's a black box. That's all you get. That to me is problematic, as opposed to something that's nuanced and actually responsive. And this has been a problem with the ISPs, which are big corporations. Sometimes city governments or county governments, whatever it is, can be quite responsive. You call up the state of California. Sometimes you can talk to somebody about this or that fairly easily. Sometimes you can't, right? But it can be done, is my point, and it should be done. And when you're gonna send somebody an intimidating message like that, that again is very heavy-handed, then you need to be able to enable a follow-up too. And so, just as we were talking about with an earlier thing, I think a lot of it comes down to the devil is in the details in terms of implementation and how it's done. And can you get, it's like the bar example, can you get your organization to have a whole set of procedures around this to make sure that it's done right? And then maybe it wouldn't be so bad.
Right.
So,
Interesting too that this is a city police force that is taking this kind of step. Adam, what were you going to say?
Yeah, I mean, this strikes me. This was kind of surprising to me when I read this article. This is an easy call. This can never work. This would never work in the United States. I can't imagine how it's going to work in the UK. Who is determining? Who can make a determination based on the face of a website whether material is copyrighted or not? And because it's not that easy. It's not like watching someone run a red light and the light is either green or red. You got to know is, okay, so who's the owner of the copyright? Did the owner give permission? Has the copyright expired? They don't have an indefinite life. Copyrights do expire. And then more troubling is, does it fall under a fair use, or in UK it would be fair dealing? Is there a defense for fair dealing or fair use? Remember, it's okay to copy portions of a copyrighted work and publish them on your website if it's for purposes of teaching or parody or commentary. Those are all, acceptable uses. Obviously there's an analysis there, and I'm speaking broadly, but it takes into account several factors. It's not the kind of decision you can make by simply, I'm the copyright police, so I use the internet every day and I visit websites, and when I see something I don't like or appears to be infringing, I then shut down all the ads on that website. Think about that. Yeah. You're garnishing the wages of the business. The advertisement revenue is likely the very money that website is hoping to earn for its business. So someone is making a determination in the comfort of their own office without, presumably, someone is making a determination without due process to the actual owner of the website, and then going further and saying the penalty is I'm going to garnish all your websites, and worse than that, I'm going to replace your ads with a warning so that no one wants to visit your website. I don't see how that would never work in the United States. I can't imagine it would work in the UK for very long. So I guess it'll be something interesting to watch.
I would have to disagree. Definitely. I mean, if I can jump in here, I mean, from a content owner standpoint, that's a little untrue as to what the PIPCU appears to be doing in the news article. It seems like it's the content owners themselves who are the ones that are running across these websites, and they're the ones that are then reporting it to the authorities. And then the authorities, it says, are then giving an option for the website to respond prior to doing any of the ad removals or any other violations of due process that might occur in that sense. So there is an opportunity to respond and say, we have this right to use this content, or a fair use argument here. So in that sense, I don't think it's really fair to say it's just some authority sitting in his office deciding what is a wrong website. And I think that from my viewpoint, this would be more helpful for websites like Ninja Video. If you remember from a few years back when that website was running, it's very clear that when a website is able to offer users who install some type of Flash plugin that does a routing service to be able to watch videos, and a lot of the ads that are surrounding these clearly illegal videos based on titles that match the exact titles that are in a torrent search, for instance. Like, you can look at a torrent and a TV show has a very common .avi or .mp4 title that even includes the name of the group that has ripped it or encoded it for that purpose. And so I think when you have clear-cut websites such as Ninja Video from a few years ago, I think that there should be an option for a content owner or a company to say, this is wrong, it's clearly wrong. And then here, they're using Google AdSense or they're using Netflix ads on their site because they know the target audience are content consumers. So why are they allowed to make money on that, on my content that I'm not allowing them to share yet, especially if it's something that's still in theaters? I mean, to me, it seems like there are clear-cut examples of when something is truly illegal and there's no possible way they have any right whatsoever to be sharing Guardians of the Galaxy the day it comes out in theaters. I mean, yeah, I just had to share that.
And I think there's an important distinction to make between what I was talking about, what Adam was talking about, and what Franklin was talking about, right? And so, when you have obvious infringement, maybe there's a way to go after that. I was talking about, I actually had my facts a little bit wrong, and I realized when Adam was talking, I had been mistaken. It's one thing to say, okay, we're going to put an ad on this particular, so this particular user can see it and give them a notice that way, because we've done an investigation about that user. But what's actually going on here is that they're just saying, and this is what Adam pointed out, right? They're just saying this website, we've decided to call this infringing, we've decided to commandeer their ad infrastructure in order to send messages to their users. They're going to drive users away and gonna replace their ad revenue, right? To me, that's shades of SOPA and HIPAA. And what was the problem with that? Yeah, you have rights holders come in and say, we don't like this site, right or wrong, let's shut it down. We've seen problems even with the current laws where the U.S. government has mistakenly shut down, or not shut down sites, but seized their domain names, or they've seized domain names without any charges or any indictment being filed, and then held on to those for as long as a year in the case of DJ's One, and then released the domain name when they really couldn't come up with facts enough to support an indictment, right? And so we've already seen unlawful seizure of sites, right? In my view, unlawful and inappropriate, at least, seizures of sites, and I think that's really problematic. And so Adam's made a good point that you can't just cannibalize. But I think that's different than saying, okay, we've done an investigation of a user and we're going to reach out to that user and have a process, right? And I think that's a middle ground sort of between what Franklin is saying and what Adam's saying. But if you're talking about just deciding, oh, well, the rights holder told us they don't like this site, they did that with, for example, torrentfreak.com at one point, which was which is actually a news site about the torrenting world, right? And they have a lot of original reporting. And so to me, that's, again, problematic if you can take these kind of unilateral actions without the right procedures in place. It can't be done. And if you look at the offline context, bookstores and newspapers, things like that, there's actually a lot of jurisprudence that says that's completely out of the question. You can't just go in and seize somebody's store, even without a court order, right? So I think we got to think about whether we're talking about targeting individual users based on evidence, targeting websites based on evidence, and what kind of process is involved.
Yeah, as you were saying before, Jack, it's going to all be in the implementation, and whether this winds up being a sensible kind of a strategy or a really overzealous kind of strategy. And it is going to be interesting to watch and see how it unfolds. Speaking of revenues and where we spend our money and where we spend our time online, I would love to point you guys over to twit.tv/Amazon. Of course, we all spend a ton of time on Amazon, whether we're buying videos over there or house supplies. I know just about every household good that I purchase these days comes from Amazon, as well as media and entertainment things. And if that's true for you too, and you're a fan of the network, then this is definitely something you need to be doing. Of course, you know that Amazon has great affiliate programs and that you can support people that you like the Twit network, just through your ordinary shopping habits. And we have a great way for you to do that here in conjunction with Twit. You go to twit.tv/Amazon. You already know the price, selection, and convenience of Amazon.com. You can help support us with all of your Amazon purchases. It's easy. You just click through the Amazon banner at twit.tv/Amazon. You'll also see links there if you're in the UK or Canada that'll work for you. And then you just shop as usual. It's as simple as that. It costs you nothing extra, and anything you purchase helps keep the lights on at the Brick House, which is very important to us. So, I just can't imagine that Amazon isn't a major part of many of our listeners' lives. I know between Amazon Fresh and every other aspect, I still use both Amazon Fresh and Amazon Subscribe to get groceries and day-to-day supplies to our household. So, it's just an integral part of my life. And I know that I now am going to shop via twit.tv/Amazon. And I encourage you to do that too. Whatever you buy, please make sure to click through the Amazon banner at twit.tv/Amazon. It's an easy way to support Twit. You can also bookmark that page and click through our link every single time you shop at Amazon.com. Don't forget there are links for Amazon UK and Canada. Once again, twit.tv/Amazon. And thank you so much for your support of our network. All right. So a sad story along the lines of infringement and the back and forth that goes on with that. I don't know if you guys remember that there was a controversy about the game company GameLoft. Its Amazing Spider-Man 2 title originally was going to have always-on DRM, and GameLoft responded to the outcry about that, didn't want to upset its users and do something that was, in their mind, overzealous and too much on the DRM side. So they removed the DRM. And just a few weeks later now, there's another title from GameLoft called Modern Combat 5 that was leaked online prior to its official release date, and the company has had to scramble and try and push up its release date so that it can get out there competing with free and have people actually buy its game. So I thought I'd just toss out real quickly here the state of infringement when it comes to video games. Obviously, most game titles are very concerned, like with most movies, that their distribution follows the agreed upon and paid for avenues. Jack, do you have any thoughts on the state of copyright infringement in the video game industry?
Well, I don't have any particular, unique insights about that. I think when you compare it, for example, to movies, I think we'll probably see more always-on DRM. Users have really resisted that. They've really complained loudly about that. And people still pay a lot for video games. There's a lot of users and a lot of people who pirate also pay a lot, but at the same time, there's more piracy. I think it's growing, as far as I understand. So I think that there's going to be a continuing battle around always on, and always on is the video game version of the streaming model of RDO and Spotify and Netflix. Which is basically you have to be connected and you have to be checking in order to play the game. And that can create all kinds of problems. At the same time, a lot of people are always online anyway when they're playing, because they're playing, in groups or or whatever it is. So, whether that'll be a problem long term is, I think, for the user community and the developers to work out. And I think there's a lot of feedback. There's a lot of, I think game developers appear to be more responsive to the users and to be more in sync with the users. And I think the fact that they have a much better relationship for the most part with their users than the RIAA and the MPAA have is deserved. But that's, so my thoughts are pretty general on that. I mean, we're going to see more skirmishes like this for years to come, most likely. Always On is going to be very attractive game developers. So lead.
Yeah, and if that's the case, they're going to have to make sure that their software performs better than ExamSoft's that we were talking about at the top of the show. Franklin, what do you think about video games and infringement?
Yeah, I mean, I'm clearly on the side of it's wrong to download. I think anybody would argue that it's wrong to download a game illegally and not pay the developer something. But what I particularly liked about the article is the writer picked out the fact that some of the common arguments are you don't know if a game's going to be worth it or if it's going to suck when it comes out. But a good way to go around that is with like the reviews that are available. I mean, you have to find a reviewer that you can trust, and there are plenty of game reviews out there. So you can even go online to YouTube and watch a complete walkthrough of the entire game so you can know whether or not you're going to like it. But
there are copyright issues with that too, though, right?
Exactly. So you got to pick your poison. But in some of the comments on this article were very interesting in that I'm an iPhone user, and I know a lot. There's so many more models of phones that you can use with Android, and I think that is a very valid argument to make that if you don't know when you're downloading from the App Store whether or not the game from the developer is going to work on your phone, then why would you waste the $7 or so? And I mean, I guess somebody said there was like a 15-minute refund window with Android Store. I'm not sure if that's true, the Google Play Store or not. But either way, there are good arguments for either side. But I think the safest thing for a developer to do is just put out a demo and let people play through the first few levels. I mean, I think they just did that with Bungie just did that with Destiny, the new game coming out. And so you can play up to I think 8 levels or 9 levels of the game, and that gives you a great sense of knowing whether or not you're going to enjoy this new style of game. But I think if developers choose not to do that or just don't have the finances available, because I'm sure it costs more money to put out a completely different version of the game, then you can't really argue with the fact that some people are going to torrent it and some people are just going to cough up the money to pay for it. So there's always going to be two sides to the argument.
Yeah, the Bungie model is a great example. I'm glad you brought that up. The other thing that I always, it's always in the back of my mind thinking about video games these days is Minecraft and how they've just taken a completely different approach to, I guess it's a different kind of game that lends itself to this approach, but having people pay their initial fee for the game, but then, the whole world of mods and maps and the fact that you can create so much content once you're playing the game and creating for others to play in the game that involve other kinds of IP being brought into the game. Pick your poison. If you're a Harry Potter fan, you're going to find dozens of Harry Potter mods for Minecraft. If you're a SpongeBob fan, you're going to find SpongeBob running around in Minecraft. And, it makes my lawyer head spin a bit, but the approach of the company toward that, at least the Mojang company, God knows, the people who own the IP rights to the Harry Potters and SpongeBobs of the world may have an entirely different take on this, but Mojang seems to have just completely embraced the explosion of creativity that has happened around the game. So I guess that would be at the other end of the spectrum of what's going on right now. Adam, what are your thoughts?
I'll probably defer to Franklin and Jack on this, but it strikes me as there's always going to be a tension between the consumers who want to use copyrighted material and the artists who are creating it and the artists' efforts to try to control access to the copyrighted work. So I get that, and I think everyone does. And every once in a while you have a clash or a collision like what we saw with the game being released illegally a day before it was supposed to be released, according to the legal schedule. So I think that's just something we have to deal with. I'm glad, though, there's pressure on the companies to try to minimize the inconvenience they cause to their consumers. Because, we just saw this week in the news where is it Renault that makes the electric car, where they used a DRM control mechanism, similar to what we've been talking about, to lock the battery for the car. And therefore, if the owner of the car falls behind on the payments, let me put it this way: when you buy that electric car, you're actually not buying the battery. You're buying everything but the battery. You are renting the battery. You're renting the battery. And if you should ever fall behind on your payments for the battery, guess what? The provider can turn off the battery. Will not charge, and therefore you cannot drive the car. So I'm glad there's pressure on even gaming companies and any software makers to be careful and responsible about the DRM controls that they embed in their product. Because, if there wasn't that counterbalance from consumers and that pressure from consumers, then I think we would see more heavy-handed techniques like you're seeing with Renault and its electric car. So.
Absolutely. And we have to now make our second MCLE passphrase, DRM my ride, I think. So that'll be number 2 for the show. Let's move on, speaking of heavy-handed, to look at what's been going on between the CIA versus Senate on the privacy front. Okay, head spinning again. We have a Senate oversight panel overseeing the CIA's secret actions, but the CIA, it turns out, got embarrassed about the fact that it had actually been spying on the senators. Jack, can you add some more detail and tell us what happened here?
I just can't believe that CIA Director Brennan still has a job after hearing this. I mean, not only was he not straight with the American people, but let me go back. So what happened was the Senate Intelligence Committee was working on where the CIA was investigating, I think it was allegations of torture, and so they wanted to see what the Senate staffers knew. So they went in and looked at their computers and got into their computers, and when this originally was leaked, and I believe it was by Snowden, but I could be wrong there. I don't think that was by Snowden actually, but what happened is that Director Brennan said, no, you're not leaking. This didn't happen. This isn't true. And of course, it turned out that it was true, and that investigators from the Department of Justice were lied to, and that the CIA staffers who did it were not straight with the DOJ about it. And so to me, this is a most likely a criminal situation, but the DOJ has declined to investigate. It didn't have enough evidence. But it's more problematic. I mean, all of this spying, it can chill people's expression. It can chill who they associate with, who they talk to, what they want to do with themselves. It can also it can also, I think, something more disturbing is it can lead to intimidation by government. Everybody knows that the government has a lot of information about you that it can manipulate and do whatever it wants to do with. That creates a real chill for people, and it's very scary, and it threatens our democracy, right? And so, originally when this whole thing broke a year ago, and I do a lot of privacy work, and I think about privacy for a long time, and so we were thinking about this, and people were suing the NSA and the DOJ and saying stop warrantless wiretapping long before the Snowden revelations. But when this whole thing hit, one of the first things Obama said was, we're not listening to your phone calls. That turned out not to be true. We were told this is all legal. This is all legal. And it's true that the FISA court had approved a lot of it. But when you see the legal justification, it's frankly laughable, because the Patriot Act provision that they're using, for example, to collect all Americans' phone calls, phone call records, not the content of their phone calls, is not intended for that at all. It's intended for business records that are relevant to an investigation, right? So now they're saying every phone call everyone makes, how long they make it, who they called, where they called it from, possibly, and some other data, is all relevant to an investigation. And I guess the investigation is terrorism in scare quotes. So that turned out not to be true. Then he said, no one's listening to the content of your phone calls. Well, it turns out that many phone calls, many emails, many chats, are actually being collected of Americans, right? Even without suspicion, sometimes on purpose, sometimes not on purpose, sometimes carelessly. And then they said, well, no one is going to be using this for prurient purposes, for sexual snooping or for spying on people's private lives. This is all just for terrorism, national security. And it turns out, no, actually, there's actually a nickname for that type of activity. It's that common. It's called love-int. And only about a dozen people out of tens of thousands of employees have been fired for it. But that's because they had to take lie detector tests and they thought they wouldn't pass. And so people's, pillow talk is being listened to and things like that. Then we had a situation where the spying was actually being leaked and given, information was being given to other agencies like the DEA and the IRS to use in prosecutions, and then law enforcement that was given that. Sometimes they were given some of that information. They were told to lie to the court and to hide that. That was being used and to create a legitimate trail and hide all of this from the defense and the defendants. So that's problematic. Lawyers are being spied on. We now have a couple of different situations there where lawyers were communications were intercepted. So that's problematic. The only thing we haven't seen is where it's being used to discredit opposition, to blackmail people for political purposes in ways that would directly undermine our democracy. It's not an Orwellian situation because this has already happened. It happened in the Nixon administration. And J. Edgar Hoover was actually, they would go to congressmen with incriminating information in a briefcase, and they would say, I'm going to leave this piece of paper here, and I'm going to come back in the room in a couple of minutes after you look at it, and then, so we need you to vote for this appropriations bill or whatever it is. We don't have any evidence of that. I don't know if that's taking place, but the thing is that when you have this much information about people, and now we see that the executive branch in charge of foreign intelligence operations is going in to look at the legislative branch's privileged or confidential information related to an investigation that touches on that agency. I mean, that is a huge, huge violation that really threatens our balance of powers, that threatens our whole system. I mean, it's incredibly disturbing. It's in many ways, on a certain level, it's far more disturbing than if just thousands of citizens having their information be intercepted and looked at, right? And the only thing we haven't seen yet is where people are being blackmailed or being manipulated with this information into changing the course of politics, in other words, the course of policymaking. And that's the shoe that's going to drop. I don't know if it's going to drop. I don't think it's going to drop in the Obama administration. But the longer it goes on and the more presidents we see that have this power, eventually it will happen. And then we'll be looking at a very, very dangerous situation. Well, we're in a dangerous situation. I think we'll be looking at a serious undermining, I guess you could say, of our system if that ends up taking place.
Yeah,
so
and there's nothing to
rant.
It was a good rant. And there's
you.
nothing to say that's, the fact that we haven't heard about those episodes happening recently doesn't mean they're not happening, because, if you're in that situation and you're a lawmaker, the last thing you want to have happen is to have it be public.
Well, yeah, and the other thing we've been told is, this is all being secure. It's only authorized people. It's not going to be leaked, except for the fact that somebody fled to Hong Kong with thousands and thousands of documents. That's already evidence of the fact that if you have this, it's going to get out and it's going to cause harm. In this case, I don't know how much harm it's caused. I think it's enabled a conversation that everybody you talk to says it's important to have. But again, there's too much being collected. There's too many people with access to it. It's going to get into the wrong hands. It's just a matter of time. And whether that other shoe will drop, Denise, I don't know. I don't know when it will, if it will, but I'm absolutely terrified that it will.
Do you think that any of the cases that are pending now in federal court that challenge the constitutionality of the scope of surveillance that has been going on, do you think that any of them have a chance?
Well, I mean, we had a case in the Southern District of New York from late last year where the judge said that the mass collection of I think it was metadata, telephonic metadata, collecting everybody's records of who they called, when they called them, and those kinds of things, was unconstitutional. And that violated people's Fourth Amendment rights. That's going to go up to the Second Circuit. Then a few days later, the Ninth, I think it was one judge. I just off the top of my head, I'm forgetting which cases, but I can get that. But there were two federal district court judges, trial level judges, within a couple of few days of each other, disagreed on the constitutionality. And I think it was a judge in the district. I think it was the District of Colombia that said it is unconstitutional, and I think it was the Southern District of New York that said that it was constitutional. But those are going to go up to the Court of Appeals. Who knows what's going to happen in those two different circuits? It'll undoubtedly get appealed to the Supreme Court, and then who knows what they'll do. I mean, we've seen some of the more conservative judges vote with the more liberal justices to uphold Fourth Amendment rights. We saw a case about GPS tracking recently, and so that very well could happen. We also had two judges that said in concurrence recently. I think it was Justice Sotomayor, it was Justice Kagan, I think, who said, we really need to look at the case that the DOJ is relying on, called Smith versus Maryland, which said that when you do business with a third party like a phone company, you don't have a reasonable expectation of privacy in your information, and so you don't have a Fourth Amendment right to that. And that Smith versus Maryland case was from 40 years ago, and is quite different in a lot of respects than the current situation. So will that get re-examined? It's really tough to tell. On the one hand, I think that the five more conservative justices are pretty establishmentarian and aren't going to want to come down real hard, if at all, on the FISA court. At the same time, you see Scalia and a couple other justices coming over to the more civil libertarian side on a number of cases. And this goes back a few years too. You can go back like 10 or 12 years or 10 or 15 years. There's a case about marijuana infrared detecting heat sensor technology, and the court said you have to get a warrant before you use technology that's not available generally to the general public. That's like sort of super sensitive technology. And Scalia was in the majority on that case. I think he actually may have even written that case. And so, it could go either way. It's really tough to call because you've got the establishmentarian bent on the one hand, you've got the civil libertarian bent on the other hand. And so it might depend on which president's in office. If you want to take a cynical view that the court is politicized, but who knows what will happen.
Hey, Franklin, we have a good article in our rundown for today that's by Megan Meager over at Forbes that's titled "Why Online Privacy Should Be the Defining Cause of the Millennial Generation." I know we're not really talking about online privacy here, but other forms of privacy and expectations of privacy. But do you find this particularly alarming, or do you kind of take it in stride?
I think it's something you have to take in stride, kind of like she says in the article. It's kind of hard to control because my generation at least, I guess, we use Facebook. I guess high schoolers don't use Facebook anymore, but messaging apps, everything like that. And so the data that we're freely sharing on these types of mediums, I guess, is being mined and could potentially be used against us. And so that's a very scary thing to consider, especially come time to apply for a mortgage for a house and everything that goes along with growing up and getting older and getting jobs. And so that's why I kind of, to the best that I can, take a stance that I want to put out there as much as possible that I want to be out there, if that makes sense. I want to control the information that's out there. But I feel like with companies like Facebook, you can't really control that because of the inherent nature of using them, the privacy that you just consider to be there when you're using a Facebook message or you're sending a photo through Instagram's inbox feature. You kind of get into this mindset of, oh, it's just me communicating with this other person, but it's not really like that. It's me communicating with this other person with this huge company knowing exactly what I'm talking about. And so it's kind of hard to see how it's going to play out in reality in the future. I mean, I would hope that, as the article explains, I would hope that generation will rise up and make a cause for the fact that all that data they have on us can't be used in that sense. But it's going to take time to tell whether or not there will be limitations on using the data that has been mined about us.
Yeah. Hey, let's wrap up the show with some patent stories. Kaboom. So the Alice case is starting to have ripples, not just among small players, but big ones too. Of course, the Apple versus Samsung and Samsung versus Apple litigation has been going on for quite some time and is some very high stakes issues at play. And apparently now the Alice case before the Supreme Court, which talked about patents being too abstract to be legally valid, has now come up in the Apple versus Samsung dispute. Some claims, some lawyers for Samsung thinks that some of Apple's claims need to be thrown out in light of this decision. That issue has been fully briefed to the court now, and we're waiting to see what the court does with it. Adam, what do you think is going to happen here?
Well, I guess it's not surprising that Samsung is now looking to the Alice case as a reason to invalidate Apple's patents. Samsung's got a hard road to go, though. One, their deadline for having done that passed some time ago, and Samsung lost the case at trial. So they're a little bit behind the eight ball. But I think their bigger problem is really Alice itself. The Alice case is a patent case that the software industry has been anticipating and waiting for some time. And the expectation, at least among some people, was that the Supreme Court was going to issue a new legal standard, and it was going to change the way that trial lawyers like myself and software companies and software developers think about software patents and whether software is even eligible for patents. But the Alice case, the United States Supreme Court decision, it didn't change existing law, really. The United States Supreme Court invalidated the patent that was before it, the patent that was actually at issue, but went out of its way to confirm that software deserves patent protection just as much as any inventive medium that we have. And that makes sense. Software is probably the basis of some of the best and greatest innovations that are taking place in the United States. So it's understandable that software is certainly eligible for patent protection. The court did, however, say, that what you cannot do is you cannot take an existing process or an old idea and then throw a generic computer into the mix and obtain a patent. Patents have to be novel. Patents have to be useful. They have to be new. And the court says, if you take an old idea and throw in a generic computer without really explaining how the computer improves that idea, then you really haven't done enough. You haven't transformed that idea to an invention. And so, Alice just really stands for the fact that, or for the principle of law that we already knew. And that is that you cannot patent an idea. Ideas are not eligible for patent protection. So what the court is looking for and what future courts are going to look for is because remember, all inventions, if you drill down deep enough, begin with an idea. So the courts are going to look for that inventive concept. In other words, has there been a transformation? Has what began as an idea, has it been transformed into something that's innovative? And that's really what the Alice Court made clear is we're going to be looking for that inventive concept, that moment of transformation where something ceases to be just an abstract idea, which is not protected by patents, and instead becomes innovative and useful and worthy of patent protection. So now we get back to Samsung. Samsung takes this court decision that it had probably been hoping all along might give it a second defense after having lost the case. So Samsung tries the case against Apple, loses, but is hoping all along that the decision coming from the United States Supreme Court in Alice will give it a new chance, a new breath of life. And so Samsung sticking to its game plan, and they have filed papers with the court asking the court to invalidate Apple's patents in light of the Alice case. The problem is, and this is the problem Samsung's not going to be able to get around, in my view, is that Apple's patents are not like the patent that was at issue in the Alice case. Apple's patents are innovative. One of them is the slide to unlock feature that we all like, to turn the iPhone on. If you recall, before there was that type of innovation or that technology, we all were dealing with switches, on-off switches, and those could be bumped. They could be inadvertently turned on. You could make unwanted phone calls, not knowing your phone was on. So Apple has a patent on the technology that allows you to touch the screen. It recognizes that you're making a horizontal swipe, and it therefore responds by turning on the computer. That technology seems easy and simple. It's intuitive. My 4-year-old figured that out, and probably if anyone has kids, your kids probably figured that out right away too, because it is intuitive. But intuitiveness and obviousness for purpose of deciding whether a patent should be issued are totally different concepts. If you put yourself back in 2003, 2004, when Apple patented this technology, that was an innovation that improved on a problem that was facing smartphone makers. So the patents at issue in the Apple Samsung case are not like the patent that was at issue at Alice. So I don't think Samsung's going to be successful. I'm not surprised they're making this defense, but I think it's a long shot.
All right. Hey, you're down in Texas where a case that we've been following has been pending and continues to be pending, despite the fact that the plaintiffs now want to walk away from it. Have you been following the personal audio case against Adam Carolla and others?
I have some from a distance. It is interesting because what we all hate is frivolous lawsuits, and what is so frustrating in the legal field, and it makes, I think, the practice of law look bad in the view of people who aren't lawyers, is what happens to the plaintiff that brings the frivolous lawsuit. My partners and I, we do a lot of diligence on our cases, and we turn down a lot of cases involving, cases that I would ordinarily want to take because they're software related, because there's no merit to them. But unfortunately, there are frivolous cases, and it is often so easy for that plaintiff that brought that frivolous lawsuit to just turn around and end the lawsuit and walk away, without penalty. And so often defendants, for good reason, they don't continue to prolong the fight when they never wanted to be in the lawsuit in the first place. They generally will agree to let the plaintiff go. So it is kind of interesting. And for the viewers, what's happened is plaintiff brought a patent lawsuit against a number of defendants, one being Adam Carolla, and then has since backed out of those lawsuits and is trying to walk away because, frankly, there was probably no merit to the case. And then, Adam is refusing to dismiss this case, and he's continuing to prosecute, I guess, as from the defendant's side, probably seeking to recover all the attorney's fees he spent up till now. So it is
Right,
interesting.
And seeking to invalidate the patent, importantly, which is the patent that claims to cover technology related to what we're doing here today. Right. So it's an interesting case. It has been an interesting case all along. It's an intimidating case for those who do podcasting or netcasting or whatever you would like to call distributing of video in a syndicated way. Adam Carolla has raised over $450,000 in a crowdfunded campaign to his fans, and is going to make good use of that war chest and continue to try and take this case to trial and get a legal determination on the merits of the patent. So I believe that's scheduled now for the end of the year sometime. So we'll continue to take a look at that. There's a good article by Joe Mullen over at Ars Technica on this if you want further details. But the Personal Audio LLC, the plaintiff in the podcast patent case, is now on the run, and so we'll see how far they run and what happens. Any closing words on that one, Adam?
That is the fear of the plaintiff, of course, is that the plaintiff started the lawsuit with a patent, hoping to get money, and then now it became clear that the plaintiff wasn't going to get money. And so the plaintiff now is just hoping to walk away with the patent, and it looks like that's going to come to court. So.
Yep. All right. We are kind of running long, so although there's much we could still discuss, I think we're going to have to table it for another day and go on to our tip and resource of the week. Our tip of the week, hearkening back to the privacy discussion we were having, a lot of people use Tor, the Onion router, when they are engaged in activities that they want to have a degree of privacy that their open internet connection would not have. The tip was that there was an announcement by Tor that they believe that people who have used their service between February and July of this year may have had their web traffic compromised. There is kind of a complicated story of some research that was being done at Carnegie Mellon University that was government-funded research, where the researchers were looking to give a talk at Black Hat to show that they'd been able to identify Tor users. And I guess when someone caught wind of this, they said, no, we're not giving a talk. We're pulling the talk. And no, we're not going to be that university who's known for having unmasked you on Tor. In any event, the tip to take away from all this is that even when you are using good privacy-oriented tools, a healthy degree of paranoia is still in order, and don't rely on those tools to be infallible. And our resource of the week, again, interested in those who gather information about us and the innovations they may come up with in doing so. Foreignpolicy.com has a very interesting database, a searchable database of all the NSA's patents. The NSA has been busily registering patents with the USPTO and all kinds of fun spy-related technology in these patents. So if you're interested in seeing what patents the NSA has and the volume and the rapidity with which those are being registered, go ahead and check out this online searchable database of NSA patents at foreignpolicy.com. The entire link will be in our discussion points at delicious.com/thisweekinlaw/269 is our episode today. Guys, this has been a really fun and wide-ranging discussion. I have learned a lot. I hope that you've enjoyed your time with us, too. Franklin, so glad that you've come through it all. And you say you were already employed and going to start work so soon after finishing the bar exam?
Yes, I'll start on Tuesday. I got hired by a company called Naxos of America. They're a classical music record label worldwide. Obviously, they have their main office. They were started in Hong Kong. But if you Google them, you can actually read a pretty interesting Wikipedia article about a court case they were involved in, about pre-1973 recordings, all that kind of fun stuff. So I'm really excited about it. I'll be starting out in like a business affairs type position, and from there we'll see what happens. But I can't officially practice law until, I guess, October. I find out results, and then November I will be sworn in, hopefully. So come that time, I will actually be able to call myself an attorney or esquire rather than just JD. But I'll actually next week on Friday, I'll be at the ABA conference, their annual conference in Boston. So if anybody is there, I'd welcome the opportunity to meet up and chat.
That's so cool. Congratulations, Franklin, and great job on finishing school and the bar.
Thank you very much. Thanks for having me. It was so much fun to be here and talk with everybody.
Yeah, it's great to catch up with you again. Jack, great to catch up with you again, too. So excited about the new stuff you have going on and the fact that you're coming down to the more civilized part of Southern California, if I do say so myself. At least, I don't know. I like the beaches here better. Let's just put it that way.
Well, I'm really excited about this new position and starting the Intellectual Property and Technology Clinic. The Intellectual Property Arts and Technology Clinic at UCI, and it's just it's life is easier in Orange County in some ways. The problem is getting there from LA.
Yeah, UCI is sort of the unsung hero of the UC system, I think. It's in a lovely location, but I don't think the word has quite gotten out on that yet. The law school is definitely something to check out if you're someone who's interested in this show, considering law school. Is the dean still Erwin Chemerinsky?
Yeah, Erwin's still the dean, and he's doing great stuff.
Yeah, an incredibly world-renowned constitutional scholar. So if you are in the market for a law school, definitely check out UCI. And if you're someone who's interested in these issues that we've been discussing today, Jack's clinic would be an incredible addition to your legal education. And
Denise,
Adam, yes.
Just to interrupt real fast, Erwin Chemerinsky,
Sure.
even if you don't go to that school, you will encounter him through Barbary. He is a very prominent lecturer for studying for those 1L classes and then also for the bar. So he's an excellent professor on Barbary as well.
Yep, he's very well known and very respected.
He's a phenomenal dean, too.
Yeah. Yes, definitely. Adam, it's been a real pleasure to meet you. The firm is Gordon, Reese, and Marcados in Dallas, Texas. And is there anything going on at your firm or with you that you want to let people know about before we go ahead and wrap the show?
Well, we just started in 2011, and we're a boutique law firm in Dallas, and we do only commercial and business litigation. We also, within that niche, we also practice intellectual property litigation. I have a background in software development. My undergraduate degree was in software, and then I worked in that field for a number of years. So I specifically like to represent software developers and software companies. But anyway, Denise, thank you for having me on the show. It was my first time, and I enjoyed myself, and I learned a lot. And it's nice to meet you, and nice to meet Jack and Franklin.
Yep, great chatting with you too. Folks, we record the show every Friday at 11 o'clock Pacific time. As it was pointed out to me on Twitter, that means 2 p.m. in the real world for all of you on the East Coast, 1800 UTC for all of you elsewhere. And we sit here and chat away about technology and intellectual property issues, privacy issues, net neutrality, everything that really is important and happening at the intersection of technology and law. So if you have enjoyed yourself and want to join us again, please do so at Friday Live. At that time is when we record. Otherwise, you can pick up the show on demand through this wonderful technology, sometimes known as podcasting, which we hope will survive any patent challenges there too. You can pick up the show on our site at twit.tv/twill. We're on YouTube at youtube.com/thisweekinlaw. We're on iTunes, on Roku, various other outlets where you're going to be able to find the show. Also, you should get in touch with us between the shows. You should let us know what you thought of today's guests and the topics we discussed. You should let us know what you think we should talk about next time and in the months to come. And the way you're going to do that is I'm on Twitter. I'm D. Howell there. My co-host, Evan Brown, who couldn't be with us this week, is also on Twitter. He's Internet Cases there, so you can get in touch with us directly there. You can email us. He's Evan at twit.tv. I'm Denise at twit.tv. We also have a Facebook and Google Plus page and communities for the show. So great place to get in touch with us when you have something more lengthy that you want to discuss or something to toss out to the community and take the temperature of other people, see what their reaction is. Those are great spots to do that. That's my son walking by in the background. Say hi, Tyler. Wave to the camera. There we go. Hi, how you doing? He's trolling us there in the back. So I'm going to go ahead and wrap the show and go spend some time with him. I have enjoyed spending time with you all. I hope that you all enjoy the next week, and we will see you next time on This Week in Law. Take care.